with you wherever you go with iHeartRadio.
AM 1470, WNN, with more of what you need to know. Don't miss Lisa Macy with the Justice Hour, Tuesdays at 1 and Saturdays at 3 on Health and Wealth Radio, AM 1470, WNN. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. You can check us out online and view all archived episodes of this show on our website at oltmanpatent.com. That's oltmanpatent.com. This evening, my guest is Spencer Kuven. Spencer is the chief litigator with the law firm of Craig T. Goldenfarb in West Palm Beach. This evening, we're going to be discussing medical malpractice, as well as the recent scandal at St. Mary's Hospital with a number of potential wrongful death cases regarding children, babies that have died during cardiac surgery. So, Spencer, thank you so much for coming on the show this evening.
My pleasure. Thank you for having me.
So, we're going to talk a little bit about the recent breaking story at St. Mary's, but just to sort of set the background for that, if you could tell us a little bit about medical malpractice in Florida and how it works.
Thank you. Sure. There's a separate statute in the state of Florida that governs medical malpractice. For example, as a medical malpractice attorney, before I could even bring a lawsuit against a doctor or a hospital on behalf of an injured client, I've got to go through what's called the pre-suit investigation period. That means I've got to go out and I've got to find a physician in the exact same specialty that I claim made some type of mistake, and have that separate physician sign a sworn affidavit claiming that they believe that the doctor fell below the acceptable standard of care. Once I get that affidavit, I then have to obtain all of my client's medical records and then turn that affidavit over with all of those medical records to the other doctor's attorney and bring what we call an initial pre-suit investigation. That phase lasts about 90 days. At the conclusion of that, the doctor can either admit that he was at fault, and at that point it will go to a binding arbitration. That means a panel of 3 arbitrators hear the case and determine what appropriate damages would be. In that scenario, the damages for pain and suffering are capped at $250,000 and can never go above that.
So just to clarify, the out-of-pocket expenses, the medical bills and lost wages associated with the injured plaintiff, that is not capped, but they do cap the pain and suffering. That's the non-economic damages.
Absolutely correct, yes. The economic damages, for example, medical bills, lost wages like you mentioned, those types of actual economic damages are not capped. What are capped are the non-economics, pain and suffering, mental anguish, inconvenience. Those damages become capped if they admit that they were at fault and that they made a mistake.
Now, what you were telling me about with the Medical Malpractice Act here, this is quite different from other negligence actions. So, for example, if you have an auto accident or a slip and fall, we don't have this procedure where you have binding arbitration and where you have caps on damages. Why is it different for medical malpractice?
A number of years back, and we're talking now 10 to 20 years back, the medical malpractice insurance industry lobbied very hard in Tallahassee to get what they called tort reform passed. They claimed that there were frivolous lawsuits being filed, so what they did was they went to Tallahassee and convinced the legislatures that this type of tort reform needed to be put in place. What they didn't say is that putting this in place has done nothing to help patient care. Unfortunately, over the years that tort reform has been in place, patient care hasn't gotten any better. So as a result of the scare that they put in place, they've now capped real damages for people that are actually injured. And what it does is it affects people that are injured the most. For example, people that actually go through a full trial and have a jury of their peers determine what the damages are, those are the people that are punished and capped.
So you mentioned insurance earlier. Most of the time when you bring these actions, you're dealing with an insurance company. Most hospitals are insured and most doctors are insured. Most of the time, isn't that right?
Well, no, actually, that's a fallacy. A lot of doctors are not insured because they feel that if they don't insure themselves, they're protecting themselves against litigation. But Florida requires that a doctor have at least $250,000 either in insurance or liquid assets that could pay a judgment if they do something that's wrong and they're found at fault. That's all they're required to have is $250,000.
Which is not very much if you have a wrongful death action.
Sadly, no. I mean, if negligence causes the death of a person and the doctor only has $250,000 in coverage or $250,000 in liquid assets, that's all that can be recovered.
And that's also true for people, for doctors that do potentially life-threatening or hazardous procedures.
Yeah.
It's the same thing for as a general practitioner that's really not doing any kind of ultra-hazardous work.
True. I mean, it's the same either way. And the sad part is that, without requiring the doctors to actually have the insurance coverage, you're putting them in a class different than any other person driving down the street. For example, if I have a tractor trailer driving down the road and strikes my vehicle and injures me, they're required to have $1 million in insurance coverage. But if I go into a hospital and a doctor treats me, they're only required to have $250,000 in coverage. Why should they get that special treatment for the same essentially negligent conduct?
And studies have shown that when you have this tort reform, like you were saying earlier, limiting the ability to sue or limiting the amount of damages that someone can recover in a tort action, in this case a medical malpractice action, that does not in fact result in insurance premiums going down for healthcare professionals. In some of the states that have had much more wide sweeping medical malpractice tort reform compared to Florida, including I believe Texas and some of the states out west that have had very serious caps on non-economic damages, and I believe that there are a couple of states that have caps on economic damages. That is, they actually cap the amount that you can claim in lost wage earnings and in medical bills. Even in those states, there has not been a reduction in the average medical malpractice premiums.
True. In fact, one of the proposals that was put forward when these tort reforms were put in place was promises from the insurance industry. In other words, some of the Democratic legislatures went to the insurance industry and said, okay, look, if we put these in place, you must guarantee to the doctors that their rates will go down by a certain percentage in a 5-year and a 10-year period. And the insurance industry refused to guarantee that because you're right, there is no reduction in the premiums over time, even with the caps, even despite the fact that less and less medical malpractice lawsuits are actually being filed over the last 10 years.
And, this all sort of goes back, and I've talked about this quite a bit on this show, being the hot coffee case from the early 90s sort of created a bandwagon that a lot of large corporate interests that were quarterbacked by the Chamber of Commerce and other business interests to launch a propaganda campaign to convince the public that we needed tort reform. In this area, especially, there's been sort of a perception that there's this proliferation of frivolous lawsuits, and that's probably something that you on the plaintiff side really, it's an uphill battle, even though it's an unfair one.
It's frustrating. I mean, it's often like the reporting you see on other type of events, let's say shark attacks. once the media focuses on a very small fraction of incidents that occur, like large verdicts or shark attacks is the example, then all of a sudden everybody's focused on just that. When in reality, the average settlement for medical malpractice cases is very low. The average number of cases filed is extremely low and has been decreasing over the last 10 years. So when they highlight these very large verdicts, which are completely out of the ordinary, it becomes very frustrating to us who are advocating on behalf of people that have regular cases in the court system, because it's not the norm. It's not what actually is happening in the court systems.
The other thing that you have to also consider is the expense of taking one of these cases to trial. You mentioned that you have to hire your own medical specialist to sign an affidavit saying that that malpractice has occurred. Certainly, if that person has to be deposed, or certainly if they have to testify, then that's going to cost a lot to hire experts and to conduct a proper investigation. When you start capping the damages, the expenses on your end don't go down.
Yeah, and it's frustrating because obviously you hear all of these people yelling and screaming at times about frivolous lawsuits. There's no way that a lawyer in Florida can file a frivolous lawsuit because of the affidavit requirement. But more importantly, from a financial perspective and a surviving law firm, I can't invest in a case where I know that I'm not going to get any kind of recovery because there's no realistic proposition that I'm going to win. I have to spend, as a law firm, sometimes upwards of $50,000 to $100,000 just prosecuting these cases and hiring experts to prove my case on behalf of my client.
And if you lose the case, you have to eat all of that.
That's it. 100% of it's gone. I eat it.
And you can't really ask the client. The client is never going to be in a position to pay these expenses, so the costs have to be fronted by attorneys. So it truly is a gamble.
It is. It's a huge gamble, and that's why lawyers are not taking frivolous cases, and that's why we have to investigate these cases very heavily before we bring one. I turn down probably 95% of the cases that walk into my office, and some of those I turn down because financially I just can't afford to bring it.
That's really amazing, because you're turning down cases that might be good cases that, if the laws were different and didn't have these caps, might be worthwhile to pursue, because the potential plaintiff might deserve justice, but just given the huge expense associated with it, you can't go under, so you have to pass, and that can be unfortunate.
Yeah, and when I say I can't afford to bring it, it's because the damages aren't big enough. In other words, if somebody's had an injury, if malpractice has occurred, but they've gotten better, they've recovered as a result of that, then the damages aren't large enough. It doesn't justify me spending all of that money on experts to bring a case if the damages aren't high enough. So it doesn't make financial sense to do it.
And of course, the other challenge you have is that the jury pool is being bombarded with the propaganda campaign, being told that there's this huge proliferation of frivolous lawsuits. The other side of the story is essentially not being told at all.
True. I mean, when I go out and pick juries here, even in Palm Beach County, which is usually pretty liberal, it still is a very common perception that most of these types of cases are frivolous and that doctors can do no wrong.
Now, let me ask you, you mentioned there are caps on non-economic damages. How about punitive damages?
No, and very rarely do you have a case that involves punitive damages in a medical malpractice scenario. Doctors are not generally, as a proposition, intentionally doing things to harm people. And so it's a very high standard for punitive damages, and those types of cases are extremely rare.
We're going to have to take a short break to hear from our sponsors, and then we'll be back with Spencer Kuven. Please stay tuned.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Altman, Flynn, and Kugler. We practice elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. Call 954-563-4814. That's 954-563-4814. Or visit us online at altmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. This is Jeff Van Treese for Talk Legal. My guest this evening is Spencer Kuven. He is the chief litigator with the law firm of Craig T. Goldenfarb in West Palm Beach. This evening we're discussing medical malpractice, and I'd like to discuss the recent news story that broke in West Palm, that is with St. Mary's Hospital. They were essentially accused of performing open heart surgery on a number of infants, young children, children that were, 15 days old, a few months old, and they've had a number of deaths that many believe, or at least those in the medical community might believe, that the St. Mary's Hospital has not become proficient at performing some of these surgeries. What are your thoughts on this case?
Very sad story. CNN did at least a 6-month investigation over the last 6 months of St. Mary's Hospital, and what they were looking at was the pediatric cardiac care unit at St. Mary's that was started a while back. They had brought in a doctor from out of state to head up this program, and this doctor came in and they started doing these cardiac surgeries on these very little babies. And unfortunately, according to the investigation by CNN, it showed that these babies were dying at an alarmingly high rate in comparison to other hospitals which were doing these type of special surgeries. At some point, the state actually came in and investigated, and St. Mary's then also requested another panel of doctors to come in and evaluate their program. And that independent panel of doctors found that they were just doing too few surgeries on these little babies to become proficient like the other hospitals in the state that are doing these kind of surgeries, and they had an exceedingly high death rate.
And what the study showed is that St. Mary's was doing about 23 surgeries per year at their facility in 2013, compared to other facilities that were doing open heart surgery on infants doing 100 or more operations. And this difference of doing 25% of the surgeries really can have an effect on the staff and on the physician's familiarity with the procedure.
True. I mean, ultimately what they found, and this is from independent physicians that came in, when you're only doing about 2 of these operations a month, it's really hard for the team of doctors and nurses to become proficient in this highly specialized field. So other hospitals, like local hospitals like Joe DiMaggio down in Hollywood, who are doing more than 100 of these kind of surgeries a year, are much more proficient at it, and as a result, their averages for untoward outcomes are much, much lower. Sadly, the motivation that some are saying behind this is financial.
And in fact, that's one of the smoking guns here, is that they can receive reimbursements from Medicaid and Medicare. The Medicaid reimbursement, which most of the infants would have been on Medicaid, the hospital would receive about $500,000 for each one of these operations that it performed. So it was big bucks,
right?
And they would be hard pressed to turn down that money to do these operations. They would want to do them at any if there was any way possible, even if that ultimately meant compromising safety. And that's what looks like what might have happened here.
It's unfortunate. I mean, St. Mary's originally was started as a nonprofit hospital. It was then purchased some years back by Tenet, which is a for-profit hospital system. So whenever working with a for-profit hospital or corporation, they're going to be looking at their bottom line and how they can earn extra money and extra dollars being brought to the hospital. These types of very highly specialized surgeries on the smallest and most delicate patients, such as babies, sometimes only weeks old, pay out at exceedingly higher rates through Medicaid. So therefore, it becomes highly profitable for the hospitals to do these kind of surgeries and want to expand programs. But in expanding those programs, it appears that it's caused unfortunate deaths.
Now, they're currently being investigated by the Centers for Medicare and Medicaid. They're ultimately the purse string, so they could, stop funding to this hospital if it finds that the hospital is not meeting the standard of care necessary. But they're not a regulatory agency. The Centers for Medicaid and Medicare don't license hospitals to practice. That's really done at the state level by ACA, the Agency for Healthcare Administration. And as far as we can tell, they have not done any investigation whatsoever.
Yeah, it's unfortunate too, because CNN actually called them and wanted to get their comment on what they were doing and what they intended to do, and apparently they were just shut down and hung up on. ACA needs to really step up to the plate and do their job and come down and actually see what's going on here at St. Mary's. Sadly, a good hospital may be getting in trouble for doing bad things, trying to expand certain programs. But in that circumstance, you need a strong regulatory agency on the state level to make sure that they're doing things correctly. And if they're expanding in areas they shouldn't, then they should be stopped.
And this is quite chilling when you think about it, because the Agency for Healthcare Administration, really, the buck stops there in the healthcare world, whether we're talking about nursing homes or assisted living facilities, skilled nursing, and hospitals. They're the ones that ultimately that provide licenses, can revoke licenses, that hear complaints and so forth. And there's a great deal of public trust put in them, because if they're not doing their job, then we're all at risk. We all have a stake in this. Even if you're completely healthy, you could be in the hospital tomorrow. And if the regulatory authority is not doing its job and it's not overseeing these institutions, then we're all at risk of medical negligence or and possibly even malfeasance if they're doing things they know they shouldn't be doing. So this has a very chilling effect, and this is something that the public really ought to be aware of.
Yeah, and as plaintiff attorneys who are representing victims of potential malpractice, we see ourselves as part of the enforcers of the standard of care. When a regulatory agency falls down, my practice steps in to enforce that standard of care and hold them accountable for what they've done. So the problem becomes, if you start then capping the amount of financial damages that can be awarded in those cases, then our ability to enforce that standard of care and punish hospitals or doctors that fall below that standard become extremely minimized. And then if you have a weak regulatory agency on top of the fact that you're capping our ability to enforce punishment, it becomes essentially a free market for corporations to do whatever they want.
And of course, we were talking about the expense of litigation and the time involved, because it can be, years later that you are ever able to make a recovery or get a settlement from these hospitals or healthcare providers. So, as far as the immediate, boots on the ground here when something like this breaks, it really is the Agency for Healthcare Administration. There really is no one else. And this is something that needs to be in the public eye, because our elected officials ultimately that appoint directors of these organizations, the public's interest has to be at stake here. And this is something that is far more important than a lot of other issues that are brought up in elections and so forth.
Yeah, I mean, the executive is going to appoint the head of these agencies, and then you've got the legislature that gives them the funding. If they appoint a head of if the executive branch governor appoints a weak head of the agency, then obviously there's not going to be enforcement. And then on top of it all, if our legislature doesn't fund that agency with enough investigators to go out and investigate allegations of malfeasance or negligence, then they really can't do their job from that level either. So if the legislature and the executive branch don't step up and appoint a strong head in addition to the funding, then really you have a weak regulatory agency that doesn't do anything.
And this is really alarming, because in the present case here with St. Mary's, one of the mothers of a child that died during open heart surgery said that she was lied to by the is either the physician or the administrator. I believe it was the physician, saying that this was a very safe procedure and that only one patient had died when other patients had died. And this really goes to the informed consent issue to a large extent, because in order to parents have to consent for their infant children. The children can't consent for themselves. So in weighing the pros and cons of whether to have a procedure, you have to be as fully informed as possible. And if you are misled to believe that a procedure is very safe when in fact it's not very safe at all, then you really can't consent effectively.
True. Or the consent that you're giving is false because you've been misrepresented as far as the safety of the procedure and the proficiency of not only the doctor but the program that you're giving the life of your child to take care of. Because there are alternate programs, and parents need to know that there are alternate programs in the state where these very delicate and highly specialized procedures can be done, even locally here in South Florida.
And, this is a situation in which you have a hospital that was probably doing procedures that it wasn't qualified to do, certainly not at the level that it was doing it. There are accusations that they were misleading the parents to make them think to give them a false sense of security that these procedures were safe when they really weren't. And then you find out they had a strong financial motivation to do so because of the very large insurance reimbursements for doing these procedures. And then when you look at all of that, none of it's been proven in court, but when you look at all of that, this is more than enough that an agency should be on this yesterday. I mean, the instant that it's made aware of this, it should be all over it, and it's not.
You would hope. I mean, obviously, that's what you would hope. It should not take a national news gathering organization to uncover this kind of a problem that's going on right here in our backyard with a hospital that a lot of people trust and take their children to.
CNN should not be the protector of the public good. That we should not have to rely on them. We should be able to rely on our elected officials and our agencies.
Absolutely.
We have just a couple minutes left. I just want to make sure you have an opportunity to give your contact information out in the event that our listeners might be in need of your services.
Thank you. Spencer Kuven, and again, I work at the law offices of Craig Goldenfarb up in West Palm Beach. You can reach us at 1-800-GOLD-LAW. That's 1-800-GOLD-LAW.
And you practice in a number of areas. You do plaintiff's personal injury, you do auto accidents as well as medical malpractice as well.
Auto negligence, any type of negligence, premises liability, slip and fall, trip and fall, medical malpractice, and nursing home negligence.
We have maybe 30 seconds or so left. In this case, the number of plaintiffs, or the number of decedents, I think it was under 20. I think it was like around 10 or so, or perhaps 15. How would that work? Would they all would they all go in together, or would they be represented separately?
Each case would have to be different. Yeah, each case has different facts, and each baby has different medical conditions, so they'd have to bring their lawsuit separately.
Interesting. So we're going to be following this story, and I'm sure we'll be hearing more as the details are to come. I'd like to give a very special thanks to my guest, Spencer Kuven. Please tune in next week, Tuesday night from 6 to 6:30. This is Jeff Van Treese for Talk Legal. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice.